Hello, Brothers Dove. I am Ron, and this is my first attempt at trying to create a video that I have been inspired to do based on the videos by the Vlog Brothers, with a V for vlog, by Hank and John, who have been great inspirations. They're about the same age as me and my own brother, and I think that their videos were a neat way for them to try to connect and communicate, and I thought that I would try an attempt at that on this. And of interest to me happens to be law and all things Supreme Court. And so we were in a discussion, and Ben, as you will remember, you had said that perhaps my bias was a little bit too much, and perhaps that I was not viewing the case of Citizens United with a proper sense of skepticism and thought. So I have taken that challenge, and I have checked out oyez.org, O-Y-E-Z. If you're interested, you can find all kinds of wonderful judicial things based on Supreme Courts and other stuff as well. Justia.com is another cool resource. And so I thought I would handle this Citizens United question. What is it? How did it get developed? And what is the big deal behind this whole campaign spending bill? So I listened to the oral arguments. Attorney Ted Olson, who used to be one of George W. Bush's Solicitor General, fantastic argument, great orator, really strong personality. And this was one of the first, if not the first, case argued before the Supreme Court by Justice Elena Kagan. She was Solicitor General for Obama at the time, and then a year later she became Supreme Court Justice. So I don't know if her feet were totally in the warm on this one yet. She actually made an argument at one point that if the state has to lose, she would like to be able to explain the way in which the state should lose, and that seemed like a strong argument to me. Regardless, the background happened because Citizens United was a big company that was able to make a video that was extremely critical of Hillary Clinton. And this was back in the 2008 season. And so they wanted to produce this video and put it out so that people could see it from within 30 days of the primary election, I believe it was. Well, it just so happens that the law did not allow, or at least provided a questionable opportunity for whether or not they could. Because in what was known as the 2002 Feingold-McCain Act, they were not allowed to use independent funds for a corporation to spend money and to create what they called electioneering communications. And this would include express advocacy for a candidate. So they were questioning whether or not they could do this, and they thought that perhaps they couldn't, but they thought that they should be able to, because they should be able to. They've got the money and they have the audience for it. So they want to be able to give the audience what it wants. And the law said, nope, can't do that. Well, the McCain-Feingold Act was designed to try to keep the big money out of politics, because as one of the dissenting opinions in the case had said, nobody really argues that there's too much money in politics. So the way that they thought would be smart in doing that is saying that there are certain restrictions that corporations have. Well, citizens decided to argue very eloquently through their attorney, whose name was Ted Olson. I'm trying to do this in one take. And he argued that there are 97%, I think he said, of all of the corporations are small business pop and shops, and that this law would prevent those 97 or 93. I am going to have to check the facts on it, but it doesn't matter. The idea is that the vast majority of people who own these businesses would have their speech shut up because of this, even though they were in the tiny little minority that was actually being affected potentially by this law. And they said that there was not express advocacy, and the court left that argument right out the door and said that it's not a musical comedy, as one justice said. And so they moved on to the next argument of whether or not they could produce a video that would be allowed to be seen, not as an advertisement that plays on TV during your regular watching of TV, but this would be something different. This would be a form of media that if you wanted to, you could you would have to subscribe to. You would have to go to Netflix and watch it free from there, or you would have to go to a movie theater and watch it there. You know, it was being offered in a few different forms, but in every case, it wasn't like it was being forced upon you. You had the opportunity to turn it down. I thought was a pretty good argument that they had made. That yes, it is express advocacy, because there's no way you can say otherwise if you've seen the video, but it's not something that is an ad that's going to just go to the general public, only the general public that wants to see it, which I thought was a strong argument. Well, Justice Roberts gets this weird idea, and he just takes it in a different direction. And thought, well, instead of arguing what this case is about, let's see if we can expand this. Let's say that this is actually a First Amendment issue for people, that people make up corporations and individuals put money to the corporations. So if you don't let these companies do this stuff, then what's the point? Like you are stifling free speech at that point, which was not the argument that was being made by the case at all. He just kind of took it there and then took some of the justices along with him, and they decided that yes, indeed, this act, which Congress decided among lots of evidence at the time, and there's court records that go back to McConnell and that go back to Wisconsin Right to Life, and I think there's another precedent in there. And they looked at these, and they didn't even bother to look at that. They didn't look at the rules for their own case that they had already passed, confirming that government has the right and has the duty to its citizens through legislation to prevent corporations from doing certain things. And it was a very limited case. Citizens tried to argue that it was a very broad kind of circumstance, and the court had said earlier that this is a narrow tailoring because it does restrict it in a certain time frame for a certain purpose, and it's across the board. It's not discriminatory. It's just that you can't decide that, and you could even argue that Citizens United just didn't fit that bill at all. You can make your movie, you can give it, even if you're within the 30 days, you just can't advertise the movie maybe. I'm not really sure. But you could even say that the law just doesn't apply to that particular case and find why. But they just decided that it was a good idea to throw the whole bathwater out. So I'm going to look into this because I still have to understand more about McConnell. I have to look at the evidence for the arguments for why they decided the way that they did there, because in this case, they completely flipped it. Even though Sandra Day O'Connor had sat with Justice Stephen Breyer, and they had talked about this and said that this was a good thing to do, and then decided that that was not a good thing to do. So I don't know, you got me, but we're going to look into that, and I will follow up with you later after reviewing those cases. But I thought that you'd be interested to see where this journey has gone. And I think I may have said some things that were a little biased, but the overall nature of my view of the case has not changed. I think the court went a little far with this one, but I'll get back to you after reviewing the other ones. And we'll talk to you later.